Now we come to concentrating on the culpability regarding our children. Can a child be held criminally liable? So this is governed by a number of acts. Currently now it's the Child Justice Act, I think it's 78 of 2000, that deals with children in our law, and this will be applicable to all our children in the madrasas as well. Our law makes a clear distinction of what type of criminal capacity exists in regard to the various categories of minor children, and when may a child be deemed to be to have criminal capacity based on their age. So there's the three distinctions. A minor who is 10 years old and younger has no criminal capacity. That's it. A minor 10 years old and above, but less than 14 years old, has criminal capacity, but that is a rebuttable presumption. And a minor who is 14 years old or more, up until the age of 18, has criminal capacity. So these three here are listed in conjunction with these three here. There is a rebuttable presumption that a minor who has not yet reached his 10th birthday lacks criminal capacity. So what does that rebuttable presumption mean? So, if you've got a neighbor's child, or the children play outside in the madrasa, I don't know, is it in grades also now? Grades 1 to 5, that age up until 10, and the child is playing outside during a break, and the child throws a window broken, 8 years old. So what's the charge over there? Malicious injury to property. The child then the next day, okay, the first day you as the madrasa teacher or the muallima, you turn a blind eye, the child was just playing. Now the next day he throws 2 windows broken or 3 windows broken. And all the children say, no, he wasn't playing with us, he picked up the stones and he threw it broken. No, I don't want to get involved with the parents, or you call in the parents, or I must open a case now because it's damaged, somebody needs to pay for it, somebody has to be fixed. And the parents come in, Allah forbid, and they say, no responsibility. My child does not have the capability to accept responsibility for it. That's the defense they're going to raise. My child is under the age of 10, he cannot be held liable. It might be a silly example, but what do you do with children that are actually violent or prone to violence? A child come in, he's 10 years old, he's with a female upper, and he takes the pen or his pencil and he stabs her with it. What do you do then? It can become complicated, this point, because children come from so many different backgrounds that a child yet. And how do you deal with a child who is prone in that manner to violence or not? So, when it comes to court, it will go to the prosecutor. Now, I'm going to stop just there. The old law, they would pick up a child, lock him up, keeping him in a place of safety, not necessarily a prison cell, but somewhere he can be kept safe from society. With the amendments to the Child Justice Act, irrespective of the offense, whether it's theft, whether it's an assault, whether it's a housebreaking, whether it's a murder, rape, or robbery, the new act says that the policeman, who is the arresting officer, has the discretion to establish whether the child needs to be taken into custody or to be left in the care of his or her guardian. For me, it's too vague. It's just too vast. Because if you've got a 17-year-old who stabs somebody dead, look back, they say you can't look into the person's future, but if you can look into their past, you can't also always blame the parents, but something's not right. If you're going to give that discretion to the police, which the current situation is now, he's then got a form, SAP 496, that they use, and he says, right, I've arrested Muhammad, or I've arrested Arif, and I'm handing him over into the custody of his parents, Mr. and Mrs. Samsudin. There we go. You need to appear in court on Monday, the 30th of October, 2023. Just killed somebody. That is the discretion that the new Act gives a arresting officer. But on the other hand, once that person appears in court, the presiding officer under the same Act can revoke the fact that he's been released, and he can be held back in custody. Now, if you are the complainant in the matter and you're dealing with children, you want justice to be done. Let's say the appa's been stabbed in the leg, or the appa's been stabbed by a 16-year-old. Come Monday, the person appears in court. They have what is called a preliminary inquiry, where you'll just receive a phone call from the Department of Social Development, from one of the social workers, and this preliminary inquiry that has taken place will ask you, what is your opinion on releasing Muhammad Arif? Just plain and simple. You say, no, they have this inquiry. Who are your parents? What is your highest standard passed? What school did you attend? What religion do you follow? Do you go to madrasa? Are you in the Quran? They have a full inquiry, and that inquiry is placed before the magistrate. The intention of the new child justice, whether they are complainants or accused, out of the courtroom environment. So many of the presiding officers and the prosecutors try to give enforcement to that act to keep the children out. But they also know when it is a serious matter that they need to keep the child in. It happens very rarely, but it does happen. It happens most of the time in your murder, rape, and robberies. But if you receive that call as a madrasa teacher and they ask you, take the opportunity to give a full explanation of Muhammad Arif, because you know the child best from that environment and how the child is reacting in that environment, so that they can make an informed decision. Okay, that's just a short background on the court processes. Then, if that child is released on that day, that's not the end of the whole court process. The child, as the accused, will be given the opportunity to be what they call diverted. So what happens is the prosecutor will take the police docket and they will go through it, check the seriousness of the offense, and see what they can do with the child. When I say see what they can do with the child, if it's a serious offense, like an attempted murder, rape, or robbery, they will then look at, do we have normal court proceedings? That's why I say it's so important for the teachers to make a complete input, especially if you're the complainant, in any offense that takes place. And then, once you've given your input, the prosecutor will then call you. Section 59 and 60 of that Child Justice Act says that the prosecutor must consult with the complainant. So you will be called in to give your input. And then one of the questions that you will be faced with where the child is under 18 is, what is your opinion on the child being diverted? So what the new act, the court process, they've got a number of programs that the child can go on to. Say stop program, say yes program, say no to addiction, etc., etc., etc. Say no to violence, whatever the case may be. They will explain to you that this is what we suggest can happen, but they'll also explain to you that the final say lies with them as the prosecutor. That is before court proceedings. So, give your full input and be honest about it. Say if you want normal court proceedings to happen. Say if it happened on previous times. Because the same way as the prosecutor is going to consult with you, they're going to get input from the accused and or his legal counsel. That preliminary inquiry, let's say the prosecutor says no. In this case, Muhammad Arif, 16, 17 years old, Molana, with a pen in the chest. Normal court proceedings and attempted murder case. It's fine. Now, the act goes so far, the Child Justice Act goes so far, when he goes into the normal criminal court and the prosecutor said, normal court proceedings, the presiding officer was the magistrate. then has the ability, without having heard the complainant, he's just got that report in front of him, without having heard the complainant or the victim, to divert the child. He or she can then send the child on the programs within his own discretion. And then the criminal case won't proceed. 10 to 1, I can almost promise you. You're going to think, but when am I being called to court? Yeah, I see Muhammad Arif is still walking around. He's not attending this madrasa. But what's happening? What's happening? The prosecutor, the policeman, if you get a phone call to say that he's now been diverted, you are very lucky. Communication doesn't happen. But there's nothing stopping you from making inquiries to say, what is the situation over here? Okay? Now, in a real world, as a complainant, it agitates you. I've now put him out of the madrasa. We had an inquiry within the madrasa environment. This is what he done. He's been suspended from madrasa. I was stabbed. I had to get hospital treatment. Everything you've gone through. You've been placed in all the circumstances. People started to talk about it. Yeah, Maulana is so bad. Sheikh is so bad. He made a case against my son. You'll always be in the bad books, Maaf, with all due respect. But people don't realize what you go through as a complainant and as a victim under, Maaf, for lack of a better, with the youth today. They have got a they just say and do majority what they feel, but everybody's not the same. So if you do get that call and you feel, but I've made all the effort, and then genuinely I would believe that those who teach in the madrasas and our ulama, they do what they do for the betterment of our society. And you're going to feel like, Muhammad Arif is walking around. What is all the effort that I've made? Am I being failed? Whatever. You need to then check for yourself, what is the update? Has he finished the programs or not? Because 10 to 1, half of the time, or 90% of the time, they're not going to give you feedback. And it presents to you as if happening. Let's say, for example, Muhammad Arif is on the Say Stop program. But Muhammad Arif then comes to madrasa every afternoon, stands at the door of the madrasa, he's suspended from the madrasa, and he just agitates you. He gives comments, and he incites the other children, and he does. You get children like that. I'm not saying it is happening, but let's say he does that. If you are not aware that he's being diverted, how are you ever going to tell that social worker, this is the devious acts that this child is still carrying out? Because the same act that put you on the diversion, if you carry on in that trend, and you're still violent and you're carrying on, you can then be brought back to court and normal proceedings will carry on against the child. So it is a very tedious process. But currently it says 10 years or below, no criminal capacity, unless you go through the process of showing that you can prove that the person knew what he was doing. Then the next one is, there is a rebuttable presumption that a minor that is 10 years old but who has not reached his 14th birthday lacks the criminal capacity. In order for the state to rebut the presumption, it has to comply with the provisions of Section 11 of the Child Justice Act 75 of 2008. So, what Section 11 says is practically in short that now the state, the prosecutor, needs to send that child not only to the social worker, but they need to go for psychological evaluation to show what type of criminal capacity the person has. Let's use the simple facts again of having stolen the money bag in the masjid. Look at what he done. He first checked out what happened in the first rak'ah, how long people spent in sajda, and then the second rak'ah, out of the masjid and hid the bag. So the psychologist or the child psychologist who evaluates him or her will then consider the actions of the person as well. Here, as a madrasa teacher or that, you will have to make an input as well. When you make your statement or when you called in for the consultation, give as much detail as possible so that a proper decision can be made. Now, we faced in an environment today where children are very advanced. If a child puts on a tablet or whatever the case may be, they'll know how to work it better than you. With those advanced minds, you also find that children know how to act to get themselves out of sticky situations. So it becomes applicable in that situation. So this onus here is just for the state to disprove between 10 to 14 years old. One more thing to disprove. Once a child reaches the age of 14 years, the normal principles apply in that he is presumed that at the time of the act of omission, he or she had the criminal capacity and had culpability, unless the presumption in law can be rebutted by other grounds that exclude a person of culpability. Now, what they say there is that if you fought between 14 and 18, you knew what you were doing was wrong. We accept that you knew what you were doing was wrong. And then you just go through the normal trial of proving that at the time when he stabbed the Molana, he knew, he's 16 years old, he knew what he was doing was wrong. We just go on with the wrong. We just go on with a normal preliminary inquiry and decide whether to prosecute or not. Obviously, at the end of that preliminary inquiry, let's say Muhammad Arif finishes the courses that he's been sent on, then only the charges are withdrawn against the mind under the age of 18. It's not just withdrawn. The condition is that he must successfully complete the programs. So let's say in the program they pick up that Muhammad Arif has a tendency to violence. Then they know that there's a problem here. We must get him on another course or whatever the case may be. They also look back into your history. So if from the age of 10 you started with your violence or your stealing or whatever the case may be, it's not that you finish the one course and the case is withdrawn against you in the circumstances of children. Your record will always show, even if you have not been convicted or found not guilty. 14 years, the record will always show what has happened to children.